I'd like to introduce the following members. We have Matthew Puz, Zoning Development Officer, Julie Maggio, Assistant Zoning Development Officer, Jeremy Toman, Board Solicitor, Tamara Doxey, Court Reporter. After the presentation by the appellant, the board will hear from those in question of the appeal, those in favor, and those opposed. Any documents or evidence that's presented must be kept for a period of 60 days for our records, and after all the presentations are made, the board will recess. We'll then reconvene and make our decisions. The board has up to 45 days to render a decision, but it's usually made this evening. If you do not care to wait for the decision, you may call the zoning office after 8:30 tomorrow morning. I now ask that everyone please stand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth? Please answer, I do.
I do.
Thank you. Listen to the appeals in the order that they are on the agenda. So first one is appeal number 24-15, Richard Telesco and Jody Fulton for property located at 4818 Wolf Road. Appealing the determination of the zoning officer for non-commercial keeping of chickens and ducks and seeking a variance for non-commercial keeping of chickens and ducks in the R1 single-family residential district. I ask that whoever's representing this appeal, please come to the podium, state your name and address.
Good evening, everyone. My name is Edward Betza. It's B as in boy, E-T-Z-A. My address is 456 West 6th Street, Erie, Pennsylvania, 16507. I am an attorney, and I represent the appellants in this case.
Okay.
I have a couple of handouts, and then I would like to briefly, I understand time is important for you. I'd like to briefly question the zoning officer and then briefly put my client up. Most of our argument is of a legal nature rather than of a factual nature. I don't believe the facts are in dispute, but I need to create a record so that the facts are at least here. So I have a couple of documents that I'll see as we go to more formally enter.
Excuse me. It's okay. Thank you.
The excitement is...
Obviously, thank you.
So we'll take the deed in as Exhibit A, the property record as Exhibit B.
That's fine.
And the zoning ordinance is Exhibit C.
And if I may ask the zoning office, who's the best person to question? All right. Thank you. Ma'am, would you please state your name?
Julie Maggio.
And Ms. Maggio, are you familiar, are you the one that issued the notice of violation in this case?
Correct.
I have a couple questions for you regarding the property. Would you agree with me that the property is located at 4818 Wolf Road?
Yes.
And is that property located in Mill Creek Township?
Yes.
Is that property zoned R1?
Yes.
Would you agree with me that the property is approximately 2 acres in size, but most importantly is less than 10 acres in size?
Yes.
In looking at Mill Creek Township's zoning ordinance, specifically section 145-11 definitions, would you agree with me that by definition this property is not a farm?
Correct.
And that is because it's less than 10 acres in size, correct?
I'm just reading the definition.
Okay, but
Yes.
you'd agree with me it's not a farm, fair enough. Would you agree with me that there is a residential structure located on the property?
Yes, there's a single-family dwelling.
And you're aware that appellants live in that structure?
Correct.
And you've mentioned single-family dwelling, but I just want to make it clear on the record, in Mill Creek Township, this would be considered a single-family dwelling detached. Is that correct?
Yes.
And single-family dwellings detached are permitted in the R1 district. And I'm looking at section 145-15B under permitted uses.
Yes, dwelling single-family detached is permitted.
Would you agree with me that the primary or principal use of this property is for a single-family residence?
Yes.
And would you agree with me that Mill Creek Township specifically by its ordinance allows for accessory uses to go in support or to go along with a primary or principal use?
Yes.
And in looking at the definition of accessory use in Mill Creek Township, section 145-11, would you agree with me that Mill Creek Township requires any accessory use to be located on the same lot as the principal use?
Accessory structure. Yes, so an accessory use is located on the same lot as the principal use.
Now, we're here about a citation or a notice of violation, and that concerns chickens and ducks. When did you're aware that appellants have chickens and ducks on their property, correct?
Correct.
When did you become aware of that?
September 3rd, 2024, we received a complaint about that. So then we investigated on September 5th.
And in your notice of violation, it seems that the issue is the keeping of chickens and ducks on the property. Is that a fair statement?
Correct.
What I want to make clear on the record is we don't have is there a setback issue or anything like that? A rear yard or side yard setback? Or are we only here because of the chickens and ducks?
Chickens and ducks are not permitted in the R1 district.
Okay, we're going to get to that, but I just want to be clear that we're not here, there isn't a notice of violation because of setbacks.
Correct.
Let's talk about the chickens and ducks. If I understand, you wrote the notice of violation, is that correct?
Correct.
And that notice is premised on the fact, or based on the fact, that chickens and ducks are not listed anywhere in the R1 district as being permitted. You don't see the words chickens and ducks anywhere in R1, correct?
Correct.
Let's go through R1, and I'm looking at section 145-15, and I'm looking at subsections D, E, and F. And I want to start with F and work our way backwards. So, if I understand this ordinance, am I correct that Mill Creek allows accessory uses in the R1 district either by right, by special exception, or by conditional use?
Correct.
Let's start with the conditional use. The ordinance, under section 145-15 sub F, the township uses the language that the Board of Supervisors may approve an accessory use by conditional use for the following accessory uses. Did I read that accurately?
If you keep continuing, yes, where it finds that all general criteria in Article
Right.
4 of this chapter, yes.
I just want to focus that it says for the following accessory uses. And then after that language, it gives a list, correct?
Yes,
And so it says, I'm about to give you a list, and it then gives me a list, and nowhere in that list is chickens and ducks, correct?
no,
When you say no, it's not there?
it's not there.
So would you agree, you cannot have chickens and ducks in the R1 district as a conditional use?
No,
No, you cannot. I'm sorry, I'm asking a question that is eliciting a no, but I want to make sure it's clear in the record. Am I correct in the statement that you cannot have chickens and ducks in the R1 district as a conditional use because it's not on the list?
it's not listed as a conditional use.
Let's go to special exception, which is section 145-15E. It has the same language. Am I reading it right? That the zoning hearing board may approve a use by special exception for the following accessory uses. And then it has a list.
Correct, yes.
And nowhere on that list is chickens and ducks.
No,
So would you agree that you cannot have chickens and ducks in the R1 district as a special exception? Chickens and ducks are not allowed in the R1 district as a special exception.
it is not listed as a permitted accessory use, correct.
Let's now turn to D. D says accessory uses permitted by right. And it says any use and their accompanying structures that are customarily subordinate and incidental to an approved permitted use, special exception or conditional, which we've already ruled out, but are permitted by right, including but not limited to the following. Am I reading that correct?
Yes,
So there's 6 items listed, is that correct?
yes,
And nowhere on that, not one of the 6 is chickens and ducks, correct?
correct.
But it allows, that's including but not limited to, and I'm allowed any other use as long as it is customarily subordinate and incidental to an approved permitted use. Is that correct?
Yes,
So I could have more than just the 6. There is an unknown 7th, 8th, 9th, perhaps 10th, correct?
possibly. Maybe a pool or a fence.
So let's talk that through. So if I were to have a tennis court, that would be a structure that would be regulated. It's not on the list, but that would be something, would your office deem a tennis court to be something, it's logically connected to the house. If the people want to play tennis, they can put a tennis court on there.
Yes,
And I can't put a tennis court by special exception or conditional use because it's not on the list, can I?
tennis courts do not require permits.
I'm not talking about permits. I'm talking about a use, an accessory use.
It is not listed.
So I can't do it by special exception or conditional use. My question is, can I do it by right? You told me I don't need a permit. Can I just go put a tennis court in as an accessory use to a dwelling?
Yes,
And a pool?
a permit is required for a pool.
Right, so some require permits, some don't. And if it's a structure and it's less than 100 square feet, I don't need a permit, correct?
Correct.
So if I were to put something smaller that's connected to the house, I might be able to do it as a matter of right, correct? Without a permit.
Yes,
In the R1, well, I'm sorry, let me go back. Mill Creek specifically gives a definition for non-commercial keeping of chickens, do they not?
Yes.
And their definition specifically tells the board and tells the residents that it is an accessory use to a single-family dwelling detached. Am I correct?
That's how it's defined.
So, my question to you is, well, strike that. We'll come back to that. So let's go through the definition. It's an accessory use to a single-family dwelling detached. And you've confirmed that the appellants in this case have a single-family dwelling detached located on the property, correct?
Yes.
And it cannot be contained upon a farm. And you've previously testified this is not a farm,
Yes.
whereupon chickens and ducks are kept exclusively by the residents of the site. My question is, do you have any evidence that the chickens and ducks belong to anybody other than the appellants?
No, I do not.
Did they tell you that they are theirs and that they are their pets?
Never received a call or talked to them.
Earlier in my questioning, you made a statement that chickens and ducks are not permitted in the R1 district. Is there anywhere that you can show the board anything that says chickens and ducks are not permitted in the R1?
In section 145-41, agricultural activities, D,
Okay. So if we look at 145(1-D, let's take a look at that. That section covers agricultural activities, correct? 145-41?
correct.
Would you agree with me that if you're not on a farm, it is not an agricultural activity to have chickens and ducks? And I'll direct your attention to the definition of agricultural activities in section 145-11. Let me perhaps rephrase. Would you agree with me that the definition of agricultural activities by Mill Creek specifically excludes the non-commercial keeping of chickens and ducks?
It does. It says the term does not include non-commercial keeping of livestock.
So when I look at, when you tell us section 145-41, you are citing to a section that governs, you've testified governs agricultural activities, which is not keeping of chickens and ducks, correct?
So that section is referring that they are permitted in the CR district and where they can be placed.
Understood. We're going to get to that in a minute. My question is, the entire section is called agricultural activities. And I'm asking you to confirm that does not include the non-commercial keeping of chickens and ducks. By definition.
Correct, by definition.
And so one may wonder, why would they put that? And then you've identified, I think exactly where we're going to go next, It specifically references that you're allowed to do the non-commercial keeping of chickens and ducks in the CR district, correct?
Correct.
But the CR district also allows agricultural activities, correct?
Yes,
Which is not allowed in the R1.
correct.
So this section that you've cited talks about agricultural activities, and more specifically agricultural activities in the CR district. My question to you was, is there anywhere in the zoning ordinance that says you cannot keep chickens and ducks in the R1 district?
It's not enumerated. We'll have a comment, it's just an accessory structure, it's defined.
Yeah. It's not listed as an accessory use permitted by right.
But we don't have an exhaustive list of the rights, do we? You've told us that you can have more than the 6.
Possibly, yes.
So my question again is there anywhere in the ordinance that's, I realize it doesn't say you can. My question is there anywhere in the ordinance where it says you can't keep chickens and ducks in the R1 district?
It's just not enumerated.
It's not enumerated.
Thank you, Ms. Maggio. I appreciate everything that you do. I have no further questions for Ms. Maggio.
Okay.
For Ms. Maggio. And I do want to clarify for the record, and this may not have been online, it's a new ordinance we adopted. There are actually 8 accessory uses. It's not updated on the one that's online. We just updated them, so there are 8.
Right.
Not specifically chickens, but just wanted to clarify for the record. Ms. Maggio, with respect to the questions regarding the accessory uses in the R1 district, Attorney Bessa, went through this with you, and, chickens, non-commercial keeping of livestock is not included there, correct?
Correct.
And if I could direct you to later on in the ordinance to section, I think it is 145-14. Which is the CR Conservation Residential District, correct?
Yes.
And under subsection E, is the non-commercial keeping of chickens/ducks listed specifically there?
No.
E, under 145-14E.
Oh, you said E?
E, sorry.
Yes.
Not D.
E, yes, it is.
And what subsection is that?
5.
I think it's 8 now, under the new amended ordinance.
An amendment? Okay.
Sorry. We amended the ordinance to include group child care home and family child care home, so that has thrown off the numberings a little bit. So number 8 would be the non-commercial keeping of chickens, ducks as an accessory. Is that correct?
Yes, I got it. The amendment, yes.
Sorry, I'll get you the hard copy of the updated version. And in this section, we've specifically, the township has specifically called out that this is a permitted accessory use.
Yes.
Now, turning back to section 145-41, agricultural activities. Attorney Bessa was discussing with you regarding that this only relates exclusively to agricultural activities. Is that how you interpret this section as a zoning officer? Or would this be something that applies as a descriptor? The heading is more of a descriptor versus only applying to agricultural activities.
It's a supplemental descriptor, yes.
So the heading agricultural activities doesn't exclusively refer to the definition of agricultural activities.
It does not.
Okay, so section 145-41A relates to commercial livestock and poultry operations, correct?
Yes.
And that is a specifically defined use, correct?
Yes.
Under 145-11. It's on page 9 of my version of the zoning ordinance. It might have moved based on some new definitions.
Yes, under the definitions, agricultural activities.
And then 145-41B has farms, whereas farm is also separately defined,
Yes.
and so on and so forth. In subsection C, non-commercial keeping of livestock is also separately defined,
Yes.
and the non-commercial keeping of chickens and ducks is also separately defined
Yes.
as a use.
Excuse me, are we referring to the brand-new ordinance?
No, we're referring to, this is the 2022 zoning ordinance. There's been no amendments.
I'm good.
Yeah, we made recent amendments,
I thought they changed some of the definitions.
not with respect to chickens and ducks and non-commercial. The new definitions I'm referring to are related to group childcare home,
I'm aware of those.
those.
Okay,
I don't believe there were any other amendments to definitions relatives to chickens. We did make a minor amendment. There was a numerical issue where it said 24, but then said 12 in a number, so we corrected those. But that was the only recollection that I have. So in 145, Ms. Maggio, -41, those are the supplemental regulations for those various uses, correct?
Yes.
And in addition to the uses that are identified in 145-14 and 145-15, there also is a use table for the township that identifies where certain uses are permitted, is that correct?
That is correct.
And their accessory uses.
Yes.
Correct? And if I can direct you to the use table, which is identified as Appendix A, page 3. Could you please identify where the non-commercial keeping of chickens/ducks is identified as a permitted use?
CR, Conservation Residential District.
Is that identified as a permitted use anywhere else in the township?
No.
Accessory use, excuse me. It's not identified as an accessory use anywhere else other than the CR district?
No.
Okay. And I do want to just clarify as well. Attorney Bessa also asked you whether or not there were any setback issues at this point in time, correct?
Yes.
And at this point, we're only concerned with the use. We haven't evaluated if there are any setback issues to the extent the use is permitted.
That is correct.
That is all I have right now for Ms. Maggio.
Just some very brief follow-up. Ms. Maggio, you were asked again about section 145-41 sub D. Again, that section only applies to the CR district, correct?
It references the CR district.
Does it apply to any other district, or does it just say accessory use in the CR district subject to the following?
That's correct.
The section where you identified that chickens and ducks are listed as a permitted accessory use in the CR district also allows other undefined uses, or unnamed uses, correct? Just like in the R1? If you look, it'll have a list of permitted uses, but it'll say any use, including but not limited to.
Are you referring to the accessory use table?
No, I'm referring to 145-15,
Okay.
If you look at each zoning district, there will be permitted uses that are listed. We're looking at accessory uses, and they contain the language that it's any use, and it goes on to say including but not limited to. And so I'm just trying to confirm that in the CR district, in the R1 district, in the R2 district, we don't have an exhaustive list of what is permitted as accessory uses. We only have some of them, correct?
Correct.
Have you reviewed the accessory use table where it specifically states non-commercial keeping?
Yes. It's permitted by name in the CR district, but my point is that there's a number of unnamed uses. You'll not find any of them on that list because we don't know what they are. We know that we're going to allow chickens and ducks in the CR by accessory use, and it needs clarification because the CR allows agricultural activities. That's why you have the whole, making an argument here, but that's why you have the whole section about agricultural activities in the CR district. Nowhere does it say you can't do this. That's subject to review if it's incidental, subordinate, and on the same lot. But if you look at the use table, it only lists the enumerated ones that we know. It doesn't list what we don't know.
Okay.
I have no further questions for Ms. Maggio. Thank you.
Brief, I just need to find one thing.
Oh, certainly.
Ms. Maggio, I just want to further reinforce, the definition of accessory use, though, provides that it's the permitted accessory use is customarily incidental and subordinate to the principal use. Is that correct?
Yes.
So it's not just any use that, even though the use table, the accessory use table does not list all of the possible uses, the proposed accessory use has to be customarily incidental and subordinate to the principal one.
Yes.
Okay, thank you.
Okay, Mr. Betza.
Thank you. I would want to briefly call Mr. Telesco.
Okay.
Or Dr. Telesco. Sure. Where would you like him?
He can probably sit here so he has a microphone. Mr. Telesco, please state your name and address for the record.
My name is Richard Telesco, and I live at 4818 Wolf Road in Erie.
Dr. Telesco, 4818 Wolf Road, is that in Mill Creek Township?
Yes, it is.
Do you, and previously we've marked as Exhibits A and B property records, do you own the property?
With my wife, yes.
How big is the property?
It's a little over 2 acres.
And is there a house on the property?
Yes, there is.
Who lives in that house?
Myself, my wife Jody, and our 4 children and our pets.
Do you have any tenants on that property?
No, sir.
Are you connected to any other, is your house connected to any other structure or apartment building of any type?
No, it's not.
You currently have chickens and ducks on the property.
Yes, we do.
How many do you have?
We have 12 chickens in the chicken coop, and we have 7 ducks in the duck house.
Do you have any roosters?
No, we don't.
How long have you had chickens and ducks on the property?
We moved here with the intent to get chickens 10 years ago, and we got them on the property 8 years ago.
What are the chickens and ducks to you?
They're part of our family. They're our pets. We've raised them from chicks, and we all take care of them.
Do you sell them?
No, never.
Do you eat them?
No.
Do you sell their eggs?
No, we just give them to friends.
Do you use the chickens or ducks for any commercial purpose of any nature?
No, sir.
I have no further questions for Dr. Telesko.
I don't have any questions.
Okay. Mr. Mensah, anyone else?
I have no additional, I would like to offer something brief to the board, but and I appreciate your time. I have prepared two things. I've prepared a brief in support of the appeal. I've also prepared what I believe are proposed findings of fact. I'm asking you to find 13 specific findings. We've covered all 13 of them in this. The only issue that I will say that has been raised that I didn't specifically question and I'll touch on is subordinate and incidental. I define and explain what the Pennsylvania Supreme Court does with those words, but more importantly, Mill Creek Township has specifically already told you what an accessory use is. They've defined non-keeping commercial or non-commercial keeping of chickens and ducks as an accessory use. And accessory uses by definition are those that are subordinate and incidental. I didn't write the language, you didn't write it, Mill Creek put that in their ordinance. So that's already been concluded, I would assert, but to the extent we want to address those issues, I have addressed them in the brief. Again, I'm asking you to find 13 specific findings, 2 conclusions of law, and render a decision overturning the appeal.
And this is the first time seeing either of these, and so I would request an opportunity on the township's behalf to have a chance to review this and respond to the brief in support and provide alternative proposed findings of fact.
Agreed, we need time as well. So what we'll say is the findings of fact is Exhibit D, and the brief is Exhibit E.
Thank you.
And were there any arguments regarding request for variance, or is that was identified in the appeal documents? I just want to make sure before we...
So to the extent I raise that, I firmly believe that this is a proper appeal and that the decision of the zoning officer is incorrect. We stand here expressing no objection to an award of a variance. The board's well familiar with the criteria for a variance. I'm not going to go into all of them, and I think there are some concerns about whether or not all of the criteria are met. I'll defer to that to you. I just want to be able to say we don't have an objection. So if the township has a great concern that this could be have a lasting effect over a number of properties, we have no objection to limiting it to this property only in any way that this board deems appropriate, but we firmly believe that the basis of the appeal is sound. Thank you.
Can I have CBAD? I can make you copies and send them to you if you... Okay. Sorry.
Lydia, do you have anything at this time?
No, I don't have anything.
Okay.
Thank you. I don't know if there's anybody else to speak, but I don't have anything further.
Sure. So now we'll give an opportunity for anyone in the audience to approach one at a time and state your name and address and tell us your thoughts.
May it please the board, my name is Gary Bax, B-A-X. I'm a resident of Mill Creek Township, and my home is in an R1 residential district. I'm also an attorney, and my law office is located in Mill Creek on West 26th Street. I did note on the appeal that there was a request for a variance with regard to appeal. I'm sure as your solicitor can inform you that there are 5 criteria for a variance to be granted, and the evidence tonight establishes none of those criteria have been met. But that's a legal argument. I would also suggest that listening to this, we've heard what is specifically listed in the ordinance. I would suggest to you that when Mill Creek Township specifically included a provision for the non-commercial keeping of ducks and geese, ducks and chickens, in the CR district, they knew how to write that special use exception. And that special use exception, which the township knew how to write, is not included in the R1 accessory use. I'm sorry, as accessory uses. So as an accessory use, the non-commercial keeping of chickens and ducks is listed for CR. Mill Creek knows how to write that paragraph. It is not included as an accessory use in the R1 district. In terms of statutory construction, the canons of construction, specifically referencing an accessory use in one and not including it in another section means that it was not intended to be an accessory use. So the questions are, is it prohibited in the R1 area? I would say yes, it is, because it was not included. Mill Creek knew how to include it. They included it in the CR. They did not include it in the R1. As a person living in an R1 residential district, I never want to wake up to chickens and ducks. I don't care if there's a rooster or not. There's a reason people buy homes in an R1 district, and I'm afraid that granting this, if you want to call it a variance, granting this accessory use would have very deleterious effects on R1 residential property in Mill Creek, and frankly, the living experience of people who want to live in an R1 district. If you want to have chickens and ducks, move to the CR district. That's the answer. Thank you.
Thank you. Anyone else? No, please approach.
My name is Bonnie Bestoso, B-O-N-N-I-E, B-E-S-T-O-S-O. I'm rather passionate about this, but very quickly, my family's owned property down there since 1956. When I grew up, there were chickens, there were ducks, there were goats, there were horses, there were ponies. I wouldn't be upset to see any of those things. Now, I don't know when the anti-poultry ordinance took effect, but if it's after 1956, I would very much appreciate it if you would consider making this a legacy. That's what this was originally used for. My second point is, a number of years ago, I was told I was that I wasn't following a certain ordinance, and I called Sue Weber, who was a supervisor at the time. She came out, she looked, she went back to the zoning board, she came back to me and she said, you are in an unrecorded subdivision. Ordinances do not apply to your property, and the police cannot even come down there unless they are called specifically. So I'd like you to take that into consideration. Thank you.
Could you please again state your name?
Yes, Bonnie, B-O-N-N-I-E, Bestoso, B-E-S-T-O-S-O.
And then address?
4828 Wolf Road.
Anyone else?
I find this unusual.
Hello, and may it please the board. My name is Peter Franklin. I reside at 4816 Wolf Road. I'm here to speak in favor of the variance being granted for the Telesco family pets. I've lived next door to the Telescos at 4816 Wolf Road for over a year. I park on the Telesco side of the lot, and I walk past the birds multiple times a day with my dog. The lot size minimum in this development is 2 acres. The development was originally a farm. Having these animals is not out of character for the neighborhood, as it was formerly a farm, and the area is currently pastoral in nature. I have never heard the chickens on the 4816 lot. I occasionally hear the ducks, and when I do, it makes me smile because it sounds like there's a nearby pond with ducks in it. The birds add to the neighborhood in several positive ways. They act as a recycling agent for kitchen scraps and other potentially garbage-bound waste. They serve as a learning tool for the neighborhood children. The Telescos are generous with the eggs. The birds are valued members of the Telesco clan, so much so that they have a bird cemetery for them. They let the hens retire and live out their days. They don't harvest them. The chickens were obtained by the Telescos after a good faith effort by Dr. Telesco revealed no apparent prohibitions against having the birds on the property. For the aforementioned reasons, I believe that a variance in this matter is proper and would not have a deleterious effect on the quality of life in the neighborhood. Thank you for your time.
Thank you. Anyone else?
Hi, my name's Heidi Fetty, and I live at 4824 Wolf Road. And my husband John and I have been there about 20 years. I'm just speaking as a neighbor. I don't understand any, legal stuff really. I just want to say I walk my dog twice a day. I never hear I never hear the chickens. There's no noise. What I see and what my husband and I see is just such a wonderful, this lovely family that's teaching their kids about, just the goodness of the animals there. I don't know, I don't find it disturbing at all, and I love having them there, and I don't know, it just would break my heart for those kids if they had to get rid of the pets. So, just speaking as somebody that lives there, I drive all the time, I'm walking, no bother at all, really.
Okay. Thank you.
Thank you.
Rob?
Hello, my name is Michael Wayhoff. I am at 4816 Wolf Road. I am the owner with my wife of that property. That is the most immediate property next to the Telescos on this side that the ducks and chickens reside. And we've lived there 5 years. So Pete Franklin, who already spoke, is actually living with us at the time. I would just affirm everything that he said. I'd like to say they are definitely pets. Our children also, it's endearing for them. They have actually named some of those ducks and chickens. To call them not pets would be a crime. We're allowed to take our food over there, our scraps, to feed them, and we watch them when the Telescos leave town. So I think I'm speaking for this whole crowd here. I don't think there's anyone that would speak otherwise against that. So I don't understand all this, but I've said enough. So.
Okay. Thank you.
We're all passionate about this.
Okay. Thank you. Is there anyone else?
My name is Allison Wayhoff. I also live at 4816 Wolf Road in the house right next to their house. Ducks and chickens are no bother to us at all. We love them. We hardly ever hear them. Quite honestly, I work from home. I work in a window that is right next to their house, and I hardly ever hear the animals. The only time I hear the ducks is when they get excited because someone is feeding them. We help take care of them, and I see no reason that those animals should not be on that house with the family where they're well treated and they're loved. I think that this is attacking a family that doesn't need to be attacked. The ducks and chickens are well taken care of. We live on a property, yes, when we bought ours, we thought we were zoned in an area where we could have livestock to a certain level when we bought our property in 2019. And so when we got the letter, we were surprised as well. I would also like to say, somebody had mentioned that it's been a farm. Just in the past week, we've had mink on our property, we've had fox, we've had coyote, we've had deer. It's rural. It is in Mill Creek, but it is rural. It is not like some of the other subdivisions when you're on a quarter acre and the houses are very, very close. We have space. That's all I have to say.
Thank you. Anyone else? Okay. Yes?
Just, I know we didn't talk about it earlier, but I didn't know a particular timeline. I'm assuming you're not making a decision tonight since you want time to review the proposed findings of fact and the brief. I wasn't sure what timeline we were looking at for purposes of if the township wants to submit anything. I'm assuming the next meeting, which is early December. Is that one of those?
Do you have a date for the next meeting?
Sure we do.
December 4th? Okay.
Okay. And in terms of how in advance you want that? I'm just trying to plan.
Understandable.
And you guys can certainly think about it when you go to decide, but that's, I just wanted to put that in your minds.
Typically, anything that we review, we like to have a week in advance.
Okay.
Yeah, there's no set parameters for submission exhibits, but in this instance, what we're discussing is reviewing the proposed findings of fact and the brief that Attorney Betts provided.
Okay.
Okay, nothing else on this appeal? Okay. We close the testimony and move to appeal number 24-16. Well, I will recircle back on that as stated at the initial, we do have up to 45 days to render a decision. In many cases, we do offer them tonight, but given the fact that we have new information that came in today, we will need some additional time to review that. So
we're going to keep the record open until the next meeting, and then we'll discuss timeline.
Sure. That's fine. I just don't want it to slip through, so.
Right.
okay. Anyone who was here for that case, we're not going to have a decision tonight on that. If you'd like to leave, we will reconvene next month. Just don't want to hold you hostage here for the next one. Appeal number 24-16, Expedite the Deal LLC for Champion Property Management LP for property located at 2502 West 26th, seeking a variance from sign regulations in the C1 Corridor Commercial District.
And before we start, I do have a conflict. My law firm represents the owner of this parcel, so I'm going to be present, but I won't be present for any of the deliberations. I guess the game plan would be for me to draft the adjudication, assuming that nobody has any objections.
Right.
Do you have an objection to that, sir?
No.
Okay.
My name is Pete Hatcher, and that's Hatcher. My address is 6487 Hilliard Drive, Canal, Winchester, Ohio, 43110. Here representing Champion. Now this wall sign, there was an existing wall sign on this elevation before the renovation.
and then they did a renovation, now they, want to put another sign back, back in that area. But Volvo branding has changed, which is why there's a backer panel. I believe you guys have the criteria, right? And our answers to those?
Yes, so the particular variance says proposing an additional wall sign, one wall sign is permitted, proposing 197.3 square feet,
Yes.
48 square feet allowed. So if you could, for the record, kind of give an explanation on that, because is it changing in kind? Is it, is it actually additional, speak to that a little bit.
Okay, so the blue backer panel is just an architectural feature that is part of the Volvo national branding, and it's to make where the white Volvo letters will be visible, especially on the white background like the building is. The backer panel is 197.3 square foot. The sign itself is actually only 21.45 square foot.
What was the existing sign?
Prior sign was 25 square foot. So this is actually smaller than what was existing prior.
So prior was 25 square feet.
And this one is 21.45.
21.45. So the issue is with the back panel.
I guess so.
That's what's Matt or Julie, that's what's been brought up?
Yes, that's correct.
Okay. I know we've had this conversation before, but can you just kind of describe that, how that comes into play? Is the back panel lit? Is that part of the...
When a sign's attached to a wall and it's just lettering, the ordinance allows us to look at just the square footage of the letters. If there's a backing to it, we're required under the ordinance to take the square footage of the whole sign, the sign as a whole, as opposed to just the lettering.
Is the backing lit?
No, it's not.
It's not
just
lit.
the letters themselves.
So for instance, if the wall were painted a blue square behind the sign, is that considered? Or is it because this is an attached being?
Yes, it's because it's attached and treated as one giant sign as opposed to just the lettering.
Okay. It's helpful.
But other than the criteria and the answers that we gave you on the criteria, I don't really have anything else.
Okay.
Just to answer any questions you may have.
And this is a corporate thing?
Yes,
it is. So you can't do anything less?
Yeah, it's just national branding for Volvo. But they need the sign to identify the entrance,
Sure. Because I'm seeing this Volvo Cars of Erie thing that's in here. And that appears that it's, the actual wall panel is just a color behind it. Like like a metal panel system just changes colors for that portion, but it's not an actual, the way this is shown from AGI, I'm not sure the sign company.
Oh, yeah.
That shows that you're basically installing what I call a metal panel system.
Right, if that's why we said
Basically, the metal panels, yeah, the metal panels behind that particular area are changed in color.
Yeah, pretty much that's about it, yeah. It's just a backer panel, just that goes right in.
But I guess my point, because it's important, the way I look at it is, this whole section with all the reliefs and everything else, you're installing a sort of, what I'm calling metal panel system.
Correct.
A rain screen system that you're installing on the wall.
Correct.
And approximately 4 of those panels, or I can't tell, 2 or 4 of those panels are a different color.
Right, blue.
But it's the same metal panel system that's on the rest of the wall.
Let me look that up for you, just to make sure.
That's what it appeared when I go to this. I don't know if this is a rendering or a picture from another location.
These ones will go across this way, so.
Well, this picture here, is this a rendering?
No,
for
not of this
location?
sign, not this particular sign, no. So you'll see, on these ones, the panel's broken up into sections. It's broken up into 4 sections, and they come across from left to right. So the Volvo, the top one, and then the Volvo one, and then the 2 below it.
Sure, the specific question I'm asking has some importance, is the same middle panel system being applied on the whole wall and 4 of those panels are a different color, or are you cladding something that is actual signage over top of the existing wall structure?
This would be over top.
It's over top, it's not part of the
It's
metal
over
panel
top,
system.
because it's going left to right. It's not like,
It's not like these pictures.
it's not like
are
these
showing.
square, look like bathroom panels.
It has a metal backing.
And you just screw it to the wall?
Correct.
Okay. Right, I was just going off the pictures, I didn't know if that was supposed to be a rendering or what it was, so.
Just a title page to throw us all off.
Okay. I don't think that I really have any other questions.
For the record, is it 2 variants that we're seeking, one for the size of the sign and then one for multiple signs on the same building, is that correct?
That is correct, yes.
But as far as the second sign, are you allowed to take the existing second sign and change it in kind? I guess my question is, if they took the existing Volvo letters off, reclad the building, reinstalled those letters, is that...
Yeah, assuming the square footage wouldn't be exceeded.
So I guess what I'm saying is...
Maybe I misunderstood your question.
It seems as though the issue is this metal back panel. The letters that were taken down are being replaced in kind with letters that are actually smaller, correct?
Yes. So the sign itself, as per the letters, are smaller than the sign that was existing prior.
Wherein that would not actually, without the back panel, it would not require either variance. If I'm...
I guess for clarification, what was the prior sign?
The prior sign, 25 square foot.
I guess, what did it say?
Really small, so hopefully I can...
The reason why I ask is I went on to...
Volvo of Erie.
Okay, and the reason why I asked is I went on to Google Maps to kind of see how long that sign wasn't, how long the sign was there, and from what I gather, it hasn't been there since 2022, so I guess it's one of those, it's been abandoned, so it's almost like a...
It's been down for...
I'm not sure.
Volvo of Erie's been down for a while?
I know it's been down since for the renovation, but that's about all I know.
Well, like I said, I verified this afternoon, and again, I used Google Map, assuming that their time and date are correct. But in 2022, I believe,
I'm just make sure we're doing some work. It does show in the picture, it was included in our packet. It did say Volvo of Erie on there.
Yeah.
You're saying that's an old picture?
Correct, and I can show you what I printed out.
Okay. Volvo of Erie, right. I mean, it was down in June, but you can also...
I thought that did something.
But you can also see that the work is going on, so it's reasonable, I think, that it would be down at that point.
Right.
No, and that makes sense.
Okay.
Like, it's kind of hard to read the picture.
Oh, yeah, sure. So, saying that, and we know it's been there for some time, it's only been down during construction, the fact that let's put it this way, if the back panel were the same color as the building or a back panel were not there, a variance would not be needed because a sign came down, new sign went up that was smaller than the existing sign in the same location, so it doesn't require the 2 signs and it doesn't require the square footage.
Correct, assuming it was put on the building within 1 year of being taken down.
Yeah.
Yeah.
So it's really the backer that's creating the issue.
Correct.
And everything, yeah. Okay. Okay. John, anything else? Okay, I think that's all we have for now.
Exhibit.
We'll recess for a bit.
All right.
Okay, let the record show we reconvened at 7:38. On appeal number 24-15, we're going to keep the record open, and we will reconvene on December 4th. We're asking for any information back from the township by November 13th, with the ability for Mr. Betts to review and reply by November 22nd. 13th, Mr. Betts by November 22nd. So is that something that you'll send to him in writing, Matt, or will you, just to make sure we're...
Yeah, I think what I can do is I can shoot out an email just with the proposed scheduling, and then if they have any objection, then I'll keep Lydia in the loop. And then I guess we'll circle back once we establish that with the township, so that the township knows. Now, does the township then reach out to all the interested parties, or just put it on the website?
We indicated that we would be doing this at the December 4th meeting. So would we have to re-advertise? I don't think we would have to.
I don't think so, yeah.
Necessarily think we would have to, they haven't passed it up.
I don't know what our past practice,
Yeah.
We'll follow past practice.
Okay. Yes, we kept the record open and we're continuing.
we may not have to put it in the paper, but we can always send out letters and we'll say, hey, it's going on this day.
And then on appeal number 24-16 for expedite the deal for Champion Property Management LP, do I have a motion?
I'll make the motion.
I'll second that. Make a motion.
What's your motion?
What's your motion?
To approve the variance.
Okay.
I'll second it. All in favor? Aye. All opposed? So moved. Do I have a motion to adjourn?
Motion.
Second. All in favor? Aye. So moved.